Fantastic. Welcome, ladies and gentlemen. Tonight is Tuesday, October 5th. It's about 7:30 p.m. We are having our Planning Zoning Commission meeting. It's a general meeting and also a public hearing tonight. Jeremy Ginsburg, the Planning Zoning Director, and myself are here in Town Hall in room 213, and we're also holding this meeting virtually as per the governor's orders. So let's get right into it. Tonight, the first item on our agenda is the general meeting. And the first item on the general meeting agenda is a business site plan application number 296, special permit application number 296, FR Darien LLC, the Commons at Noroton Heights. Request to establish and confirm outdoor dining areas for multiple food establishments. This, as everybody knows, is the federal project in downtown Noroton Heights, is what we call it. Tonight we're going to have Sarah Ford here representing the developer. She's a project manager on the project. We've gone over the outdoor seating requirements and requests from federal numerous times. I think the developer just wants to confirm where the possibilities of having outdoor seating can be, so they can keep the project moving as fast as possible forward and also secure some additional tenants. As you may have read in the paper last week, they announced 4 tenants that are going to locate to the property: a nail salon, a pizza place, a coffee place, and an ice cream spot. The ice cream place sounds really cool. Jeremy, want to give us a quick overview, please?
Sure. As Steve mentioned, Sarah Ford's here tonight to talk about outdoor dining and areas that she can represent to potential tenants that have been approved for outdoor dining. Certainly, many of the spots she shows us tonight will not end up being restaurants, but it gives her the flexibility to, I'll call it, market different spaces for not only quick serve restaurants, but full serve restaurants. And it's possible that things get adjusted in the future and she comes back, but at least review and action by the commission tonight allows her to start pushing ahead with leasing. Certainly the details of the outdoor seating areas, umbrellas, street furniture, etc., will go to the architecture review board. But what Sarah's looking for tonight from the commission is a blessing on general areas, which will end up being less than what's shown.
Correct.
Sarah, take it away.
You summed that up very well, Jeremy. I don't have too much to add. I don't know if folks had the opportunity to look at this plan in advance of the meeting. What we did here is we highlighted in blue the areas where we are asking for approval that we could allow for outdoor dining should a tenant want it.
Yeah.
To Jeremy's point, just because we're showing blue does not mean that we're going to have outdoor dining in all of these locations. So just to give you an idea, the space 114 is specifically where we have Malto on board. So that's a pizzeria Italian concept out of Fairfield. That's where those guys will be within the project, and this is their outdoor dining zone. And then as another example, space 308 is Gloss Lab. So that's the nail salon. So we've identified this sliver that's, if you zoom in, you can see it's about 2.5 feet wide. So that's just enough space for a 2-top table where it gets the most pinch while maintaining a 5-foot pedestrian clear area. In the case of Gloss Lab, there's no reason why a nail salon would want outdoor dining. So this is simply that we have the approval from the Planning and Zoning Commission. If we end up with a tenant that requires it, in this instance, this will not actually be outdoor dining. So you can see all the areas in blue where we've proposed outdoor dining. The red area we identified on the plan where we're seeking approval for non-exclusive outdoor dining. The blue represents the opportunity to allow for exclusive outdoor dining. A good example of non-exclusive would also be like something in here, which is in between the blue area and the public plaza easement. this whole zone is public plaza easement, so we know it cannot be exclusive. If for whatever reason we ended up with a quick serve concept here and they wanted to put up a couple of two-top tables, we'd like to be able to offer that to them with the caveat it's not exclusive, right? There's also a public plaza easement in place. That's not exclusive, Mr. Tenant, for your use. That being said, spaces 320 and 322, we do not envision being food concepts. 324 is Van Leeuwen, so that's the ice cream concept right here that we're all really excited about. And space 410 is Gregory's Coffee. So again, just trying to give them the sliver that was carved out of the public plaza easement area in case they wanted to put up two top tables exclusive for their use. And then we have a more generous outdoor dining zone we're proposing by space 326. I think that's the broad brush. Does anybody have any questions?
I think all we really need, I think, Sarah, is broad brush, because obviously it's a moving target, and you know, we don't need to get super into the weeds now. So you answered how wide the sidewalks are. We got that. Off the top of your head, of the overall square footage, do you know how many square feet is supposed to be restaurant and how much is supposed to be retail?
So
percentage-wise?
Yeah, so per hour, if you were to just look at this half of the site and exclude Equinox and Walgreens, the split between the retail and the restaurant from a parking perspective is about like 72% retail or quick serve and 28% full service restaurant. Okay,
that's fine. So, I mean, like, obviously, the one that you had on there is 102. That looks like a bigger tenant space. We're going to say, it's just guessing, it's over 15,000 feet.
Correct, yep.
Yeah, I don't really think you're going to have outdoor dining in front of that thing unless it's a banquet hall.
Correct. Or in the event, if we were to end up with a small format grocer if they had prepared foods and wanted to offer a couple tables, I think that would be the only real likely scenario.
Makes sense, because that's what Whole Foods has, and I don't think Trader Joe's has it. That's great. I'm fine with it. Any commissioner have any questions on this item? Jim Rand, you okay?
Jim says okay.
Jim, no, he said 1 minute.
I'm sorry, I forget.
When you do thumbs up, I know you're okay. I know when you do thumbs up, you're okay. When you do 1 minute, that means you had something to say.
This is still governed by, or would be governed by, the general conditions we've got all over town, would it not?
Yes.
I mean, we've got a sort of a format within which, or a template within which we've approved specific applications. The template, I'm assuming, would be the same here.
The template is basically the same, but within shopping centers, be it Good Wives or be it this one, we don't get super deep into it. With David Genovese's project, we reviewed his when he put a lot of outdoor dining around 1020 Post Road. Some of the other ones in town, like Bodega and the Goose and Ernie's, a lot of that stuff is technically temporary. None of those came back for a permanent. So because this is inside a shopping center, we don't need to get super in the weeds. What we allow them to have, because I mean, I had dinner the night of the hurricane underneath the awning at Good Wives, and we never saw that application. That's why they just want to make sure that they can offer to tenants and they don't get caught in some way, shape, or form later.
Okay, thanks.
Jeff, you good?
I'm good, thank you.
I'm good.
Great. Thanks, Jen. And Kara Gately. You okay, Kara? I know Kara's on a little bit of technical difficulties. I think that means she's good. All right, great. Thank you, Sarah.
Thank you.
I guess we'll take a quick vote on this.
Yeah, take a quick vote, and that way we can send a letter to Sarah confirming the vote.
Fantastic. Okay, entertain a motion to approve the request as submitted. Jen Leahy makes the motion. Jeff Ball makes the second. All those in favor?
1, 2, 3, 4, and waiting for Kara.
Carrie, you can probably say yes. I think, Sarah, you're approved. So we're trying to cut the red tape so you can get this thing moving.
Thank you. I appreciate it.
Am I allowed to make an announcement that you're going to be missing for the next 2.5 weeks?
Sure.
Sarah will be missing for the next 2.5 weeks. She's getting married, so she's trying to tie up all loose ends she can so she can go away on her trip and not have to worry about this project.
So thank you for helping me tie up this loose end. This is great.
Congratulations.
Thank you.
Thanks, Sarah. Take care.
Have a good night. Bye, guys.
Okay, we're going to switch to the public hearing now. The public hearing is a redo from last week. Continuation of public hearing regarding subdivision application number 424C as in Charlie, coastal site plan review number 360, land filling and regrading application number 512, Jennifer and Margaret Tweedy at 108 Nearwater Lane. With that said, I would like to thank Jennifer Leahy for chairing last week's meeting and going through all these applications that some we may look at tonight and some are going to be new. But thanks, Jen, for this. If Jeremy wants to explain what we're doing here on this one, I think it's just about the trees. But thanks again, Jen.
Sure. At the last meeting, we had a very comprehensive presentation by Wilder Gleason, Craig Flaherty, and the rest of the team, including the property owner, Mr. Tweedy, about the subdivision off Nearwater Lane. We covered a variety of topics, but the hearing was basically left open with the biggest question remaining there's 3 trees near the existing, I'll call it a shared driveway / private road off of Nearwater, off the east side of Nearwater. And the question is about the street trees and how much of an impediment they might be to sight lines. So commission members were asked to go out in the interim time. I think Attorney Gleason and his team are pulling together a little more information about that. In addition, we had another question that was about drainage that was forwarded to Mr. Flaherty for him to follow up on. So I'll leave it to Mr. Gleason, Mr. Flaherty to try to follow up and get feedback from the commission on the trees, which my recollection is they are town trees in the town Nearwater Road, Nearwater Lane right-of-way. So they're town-owned. They're not obscured with branches. It's the tree trunks that are partially inhibiting the sight lines coming out of the driveway. It was acknowledged at the last hearing that many of the people coming out of this driveway are likely to go northbound towards Boston Post Road, towards I-95. Very little of the traffic is going to make a left turn going southbound. So I'll turn it over to the applicant and their team to follow up on information from last meeting, any remaining topics or issues.
Great, thank you, Jeremy. Wilder Gleason, I'm sorry my camera doesn't seem to be operating again, but Fred, if you could allow me to share the screen, I can sort of reset the issue for you and share a screen that we had before. Can you all see this?
Yes, we can. Thank you, Wilder.
All right, so this is our first set of pictures. It's the driveway entrance exit as driveway number 1 is looking north from about where your car would be located if the front of your car were just touching the pavement of Nearwater Lane, which is to the left here. And you can see there's a significant, I think it's a 60-inch oak tree north of the driveway curb cut, and it limits the sight line. That distance is about 190 feet to the north. And the distance to the south appears to be more, but according to our sightline sketch that Craig had, it appeared to be about 120 feet because I think the lane comes in. It's not looking at the left, the right lane going down, but the left lane. And so that sightline distance is about 120 feet. And the commissioners, we pointed out that there is a public policy in your subdivision regulations to preserve specimen trees. The 3 trees in question, this one to the north and the 2 to the south, this one and the one behind it, are quintessential specimen trees. And under your regulations, you should be preserving them, and yet you have the conflict of the regulations say for safety's sake, you need to have 280 feet of sightline distance either way. And so the question is safety versus looks and treescape and streetscape. And frankly, the Tweedies they don't feel they can make this decision. It really falls within P&Z, and they were happy to take the trees down if you think that's appropriate. And they certainly would understand if the commission were to say safety is more important than trees. And so we recognize that. We're happy to take the trees down if they need to come down. All 3 of them, or 1 of them, 2 of them, whatever makes sense. And if commissioners have questions, hopefully you've all had a chance to visit this site. I did get a comment from Jeremy, who was clipping an email from one of the commissioners, who walked out and said that the driveway to the north was, really obstructed. And we thought that commissioner may have been actually at 108, which is the Tweedy driveway entrance, which is down the road a little bit in this driveway 2 slide. And Jim Tweedy had indicated to me that the driveway looking north from his exit driveway at 108 is quite obstructed. But this one, according to our charts from Craig, and I'm going to ask Craig to review those for you all, is really is a further distance than what you would see out of the Tweedy driveway at 108. So, Craig, do you want to just review that slide of the sightline distance with everyone? And and Fred, if you can hand the hosting to him, that would be great.
Sarah, you have a question?
I do. A clarifying question. So if it's not 108, what driveway were we supposed to look at?
It's the one, see that, it's number 90.
What number is it?
It's 88 and 90. Those are
We were supposed to go look at 88 and 90, not 108.
Yeah, and Karen,
Okay,
yeah.
thanks.
But
Joe's
this is what you'll see when you get there.
Well, I guess now I have to drive back out to 88 and 90.
Oh, geez, I'm
I drove
sorry.
out to 108 today.
Yeah. In any event.
No, actually, I drove out there today to 108.
And I understand because it's labeled 108 because that's the residence, but the driveway is actually north of it.
Perhaps that would have been useful information before I drove out there.
Well,
Right, we kept the hearing open specifically to have us drive out, right?
Kara, I'm sorry, there's been a miscommunication.
Why the meeting was held open for what purpose?
So that commissioners could go look at the sightlines.
Right.
Anyway, Craig, do you want to take us through? I apologize for the inconvenience, Kara, if you were not able to see it from the driveway itself.
I went to the driveway that was identified for us and we were told to go to.
Okay. Craig, do you want to go through your slide?
Happy to. So first, just to avoid any potential confusion in the future, the drawings are labeled 108 Nearwater because that's the tax assessor's address of the parcel that's being subdivided, which currently is accessed via the Tweedy's improved driveway that goes up to their residence here at 108 Nearwater. And that driveway comes out at Nearwater Lane here. The proposed common drive or road that we've been talking about is in this right of way here in parcel C3 that currently provides access to 90 Nearwater Lane and to the rear 88 Nearwater Lane. And so, whereas this is the Tweedy's existing driveway, this is the proposed road, which currently serves to access 88 back here and 90 up here. So we looked last time, so it's basically the next driveway to the north from 108 is where this common drive is going to be located. We looked last time, this was the roadway geometry. We looked last time at this exhibit. This tilts north to the right, just so we could fit it on the sheet. So north is to the right. This is Nearwater Lane in each of 3 plan view insets that indicate 3 different things. The one at the bottom indicates that if your driver's eye was set back 15 feet from the edge of travel way, as would be required by the DOT regulations that the town follows, the sight distance would be very obstructed because you would be set back farther from the road edge. So you'd see 97 feet to the right, 82 feet to the left because of these 1, 2, 3 trees. The next inset, again, as we described last time, indicates the available sight distance if the car front nudges forward to the edge of Nearwater Lane. Looking at that point, your driver's eye is closer to the road, so it's a little bit easier to see around the trees. In that diagram, you're able to see 188 feet to the right in front of the oak tree that's just to the north of the proposed drive entrance. And you can see 116 feet to the south in front of the maple tree to the south of the drive entrance. And then in order to fully comply with the sight distance requirements, the 3 trees could be removed. In such case, we could put the driver's eye back at 15 feet again and see at least 280 feet in each direction. So those are the calculations, those are the numbers, that's all on sheet SE6. I guess while I'm talking, I'll also just answer the other question we got quickly by email, which was, did we take any credit for the existence of the paddle court when we sized the proposed infiltration system? And the answer is no, even though the paddle court is being removed. So we effectively treat the area where the paddle court was as fresh meadow. In fact, the infiltration system is sized for the area tributary to it, which includes the lion's share of the new road, includes all of lot 1, includes all of lot 2, includes the driveway of lot 3, all of that impervious coverage with no credit for any existing impervious coverage, no credit for the existing driveway that's there, no credit for the paddle court, no credit for the shade. And those are the 2 things I was going to say. Jim, do you have a question?
Yeah, I have 2 questions, if I may. One, who's going to own this driveway when all is said and done?
It'll be a private
or public. I'm not sure which either one of those means, but
private road, so it'll be owned by an association of the lot owners. So first, it'll be the 3 lot owners that are on the Tweedy property now, with a requirement that the other 2 lot owners that access it participate as well.
okay, thank you. The second question is, would it not be practical to split the baby by putting a speed bump next to the tree.
In Nearwater Lane?
Yeah, no, not in Nearwater Lane, in the new road.
Well, the road exists today. That's Joe King's driveway.
Yeah, we're proposing a full stop bar and stop sign. So the folks that approach the end of the road should be, fully stopped. Speed shouldn't be an issue in terms of sight lines.
At the end of what road?
Our proposed access to these lots that we're subdividing is technically a low volume residential street.
No, well, it seemed to me, looking at it, that the danger, if that's a word I can use, is from automobiles turning into the new road from Nearwater Lane.
Oh yeah, that's not the way that I'm looking at it. In fact, the sight distance is if you're out in Nearwater Lane, let's say you're driving south towards Weed Beach.
Yeah.
And you're slowing down to make a left turn into this new road, right? That would be a situation where you have to stop, you'd have to see ahead of you, and you'd have to make a turn at the right time. You can see forever. So sight distances are not an issue if you are in Nearwater Lane.
Okay, but if you're in one of the new properties that uses the new lane as a driveway,
yes,
or access to their individual driveway, that's where the problem.
Yeah, so when we talk about this intersection sight distance, it's if I'm leaving my house, so it could be the existing two lots, 88 and 90, or the three proposed lots. You're leaving your house from one of those 5 properties, and you arrive at the edge of Nearwater Lane. What do you see when you get there?
The trees that we're talking about removing are not on Nearwater Lane, they're on the new driveway.
No, they're on Nearwater Lane. These are 3 trees in Nearwater Lane. Here, you know what? I'll call up kind of the Google Street View.
Let me see if I can just cut this off a little bit. At the end of the day, I've been to 90 Nearwater Lane, Joe King's house, dozens of times. I've driven in and out of this driveway dozens of times and made lefts or right. When you make a left, you go into the beach. When you make a left, you go into the beach. When you make a right, you're going back to the post road. I would venture to guess that it would be better today if we grant a waiver for these guys to leave the trees there. Because I don't know if you want to take out 2 trees in front of Joe King's house. Joe King could have come to the meeting.
But
He
is
was
Joe
noticed
King
about
here?
it.
Is Joe
Hold
King
on.
here? No, I mean, this is annoying, like, to be frank.
Just hold on
like,
1 second, Karen. Hold on 1 second. So at the end of the day, if we say, yes, you have to take out the trees, then it's going to go in front of the tree warden, and then the neighbor's going to go crazy. You're adding a couple cars to a driveway that already exists and a road that already exists. So I know it's in the subdivision provision that you have to regulation that you have to either take them down or you have to grant a waiver. Those trees have been in front of King's house for years, and the one to the north has been there for years. People have commented on this driveway for years. It is a driveway. It's a private road.
Now for King, and he's not here. You can't testify for him.
Kara, can you stop interrupting, please? I will recognize you in a minute.
Or I can.
Okay, so at the end of the day, those are the 2 options. Either you force them to take down the trees, or you grant a waiver to leave the trees, and you can come back to this at another time. Is that your understanding too, Wilder?
That's those are the options that I see, or you can split the baby, but that's
Which is what, take down one of the trees that's closest to Joe King's driveway or this new road?
Yeah,
There's
and
trees
one to the
sitting there.
north, whatever. I just you guys need to. I think we are agnostic on this. We think that this is a policy decision that the board should be making. My initial thoughts were that we ought to keep the trees, but I can certainly understand why people would feel that for safety's sake, they should be removed. And as I said in our initial presentation, we've had 2 people using this driveway for over 40 years. There's been no issue. We're doubling the traffic that's exiting. And there's a balance that has to.
You're going from 2 to 4.
We're going from 2 to 4.
Houses, not
Wanna-
drivers. Houses, not drivers, correct?
Houses, that's
How many
correct.
drivers?
Well, it depends on the number of occupants in the house, Karen.
Exactly. So perhaps more than 2 and more than 4. Yes?
Well, we were saying 2 houses existing, going to 4 houses.
2 houses, not 2 drivers.
That's correct.
So
2
you
houses.
are increasing the intensity of use, yes?
We are doubling the intensity of the use potentially.
Potentially, plus their gas, probably more, yeah?
Okay,
Wait, and the sight line, and the regulations are there regarding sight lines for safety, correct? All right, if we're not going to answer questions, then I'm
Well,
not going
the
to.
answer is yes. Kara, the answer is yes.
How close is this location to a school? How close is this location to a school?
There is a school up at the corner.
Yes. So, and how close is this to a public beach?
It's close to a public beach.
So
Very
there's
close.
already, is there a lot of pedestrian, bicycle, scooter, walker, stroller traffic on this street?
There is a significant amount of pedestrian and other traffic on the street, on the sidewalk.
Thank you.
okay.
George,
Perhaps I could just take a pass at orienting Mr. Rand so he's clear on exactly the trees that we're talking about.
Sure.
That would be helpful since the address was wrong.
I'm just going to use Google Aerial and go down to Google Street View. So again, this is the driveway. It's Nearwater Lane. This view is going up and down. North is up. This is the existing driveway to 108, the existing Tweedy residence, the Meadow property of the existing Tweedy residence. This driveway you see here is the driveway that's used by 90 King and 88 Keogh. So if we zoom in here, this is where our proposed road is coming out, right where the existing driveway comes out today. So the trees we're talking about are in the edge of Nearwater Lane. So as you're driving out this road and looking north to the right, or driving out this road and looking south to the left, you'll see 3 trees. So coming down into Street View, here's that existing driveway.
And
There
that's, you're staring at 90 right now. That's
Yeah.
90. That's
Yeah, exactly.
King's.
This is on the right. This is King's house. This is
Yep.
90. So the driveway
Correct.
going to the back goes to Keogh
Yep.
88. The driveway that
Yep.
peels off to the right is King at 90. So if you were to come out of this with your car and look to the right or north towards Hindley School and the Post Road, you are obstructed by this tree right here.
It's just
And
been there for 40 years.
over 100 probably. But if you come out this driveway and then look to your left to the south, these are 2 trees that would obstruct your ability to look to the south. So those are the 3 trees. They are in Nearwater Lane, and the sight distance that we're talking about is driving out of the new road, which is going to be right here where the existing one is, and looking to the right and looking to the left, up and down
Great.
Nearwater.
Craig, could you go back to the 2 trees that are south on King's property and point out the driveway for 108?
Oh yeah, so right here, okay. If you went to 108, you went to this driveway right here. And so if you were pulling out of that driveway, you would see these 2 trees, this tree much closer to where you were trying to pull out and see. So it makes sense that you would not have been able to see very far looking to the north from the 108 driveway. But this is where the road is going to be and where it's been shown on the plans the entire time.
Great. The road's always been there, though, Craig. It's not, you're not
It's not a
Yeah.
road, it's a driveway now.
Driveway, it's a private
It's a
road.
low volume local residential street, I think, per your regs.
Okay, thank you, Craig. And the regulations currently require certain sight lines, and now it's gonna become a road, a low intensity road, yes?
100%.
Okay, does any commissioners have any questions on this? George Riley, have any questions on this application, on this item?
No, I will just comment that I did take a look at that line of sight, and I think it passes muster, frankly. I was concerned about it, obviously, that's why I raised it a week or so ago. But
Yeah.
having experienced it and given low volume, I can live with that for what
Yeah.
that's worth.
At the end of the day, we're not making any decisions tonight. We're just trying to close the hearing. You know, so we can debate the trees till the cows come home after we close the hearing. Jen, you okay? Any more questions?
I went to the site as well. Not that I want to start making, I found the trees to be okay. So, but again, I'm not a tree expert or a sightline expert. We have experts that are hired to do that, but from when I was there, I didn't think it was
That's fine. We're just trying to close the hearing, that's all.
okay.
Jeff, Paul, any questions on this one?
I'm all set for right now. Thank you.
Okay, Carrie, anything else to add? No, you're good? Okay, anything else we have to worry about on this application?
Unless commission members have comments on anything other than those issues, we could close the hearing. Unless there's someone from the public here who wishes to speak.
Okay, we'll go one more time. Anyone from the general public would like to speak to this application? Seeing, hearing none. Wilder, you all set?
We're all set. I want to thank you all and appreciate the comments. And let's close the hearing.
Great. Okay, with that said, I enter a motion to close. Dan makes a motion to close. George, Jim Rand seconds it. All's in favor? Great. Hearing's closed. All right, next item. Next item, this part of the public hearing again, proposal to opt out of multifamily parking requirements set forth in Public Act number 21-29, section 8-2 of the General Connecticut Statutes. This proposal is the Planning Zoning Commission's official notice of intent to initiate the process by which a municipality may opt out of the provisions of the subdivision 9 of subsection D of section 8-2 of the Connecticut General Statutes regarding the limitations on required parking spaces for multifamily dwelling units. This is something that we have been discussing for over a year. When this whole desegregate thing and all the zoning applications or changes started coming down in the state. During that time period, the Planning Zoning Commission looked at our zoning regulations relative to parking, looked at other regulations relative to parking, sought testimony from experts that are parking experts, one being a gentleman named Craig Flaherty who works at Redis and Mead. And we came up with our own revised parking regulations from what had been on our books. We've got some memos and whatnot. I want to hand over to Jeremy for a second, relative to these items. If you do remember, when we had our public hearing relative to this, these proposed changes, we had a public hearing where Terry Wood showed up and gave some testimony, and also Matt Blumenthal showed up and gave some testimony. The reason why these opt-out provisions were put in is Matt Blumenthal in specific wanted the opt-out provisions, was happy with it because it gives towns like Darien and other towns that are under his jurisdiction the flexibility to do what is best for their own town. They were specifically put into the bill for flexibility, is what we want. At the end of the day, I think Darien knows what's best for Darien's town, and how we can handle how we can handle the parking. We don't have a whole lot of multifamily projects in town. We do have Avalon. We do have the Heights.
Garden homes would be an example of
Garden
standalone.
would be another one. It's a standalone apartment complex. We may have more in the future, but these opt-out rules were specifically put in the bills to give towns like ours and other towns flexibility to do it. I'm going to hand it over to Jeremy. There were certain things that we got provisions from town council. I can tell you once again, Darien and Jeremy and the staff is way ahead of the curve on all these opt-out provisions on how we're supposed to do it relative to the state statutes. And again, other towns are calling him and asking them how they're doing it. But Jeremy, please take it away.
Sure. This will be a fairly succinct presentation. I want to talk about two aspects: the procedural aspects, which are in the law in terms of how to opt out, and then I don't think I have a presentation for this, but I'll just talk a little bit about the procedural and then also the substantive. So procedurally, as Chairman Albani acknowledged, recent state statute, which turned into Public Act 21-29 passed, which amended the zoning enabling statutes 8-2, which now limit how much parking a planning and zoning commission can require for multifamily projects. In that Public Act 21-29, there is an opt-out provision. That took effect October 1st, 2021. So the Planning and Zoning Commission was not able to have a hearing before that date. So really, to opt out is a multi-step process, and I want to cover that briefly, both for the commission as well as any guests in the public who are here tonight. The first step is for the commission to hold a public hearing, which is tonight, take input and feedback, both in letters, emails, verbal comments. The commission will close the hearing, and they have time to make a decision. Next up, if it's a positive vote by 2/3 of the commission, in our case, 4 out of 6 members or more, 4, 5, or 6 members vote in the affirmative, this will then go to the town's legislative body, which is the 100-member representative town meeting. Tentatively, this item is on their agenda for Monday, October 18th, if it passes the commission between now and then. At that time, the RTM will similarly take input and vote. It would also have to pass the RTM by a 2/3 vote for the opt-out to take effect. So I want to acknowledge many of the documents that are part of, quote unquote, the record in this matter, items that have been given to the commission or the commission's familiar with that have been given to you and you're aware of, which will help you make this decision on whether or not to opt out. The first document is a 2-page memo given to the Board of Selectmen dated September 23rd, 2021, which talks a little bit about the statute and the commission's process for opting out and the commission's recent changes to the parking regulations, which I'll talk about in a minute. The other is a 1-page memo from Attorney Wayne Fox, dated October 4th, 2021, which talks a little bit more about the statute and the provisions of Public Act 21-29. You also have a copy of Public Act 21-29. It's about 28 pages. You have a draft, which has been shown to you before, opt-out calendar relative to the timing for opting out. And the last thing I wanted to bring to your attention, which is something that the commission has approved in the past, which is, as Mr. Albani acknowledged, in May and June, the commission held public hearings on your parking requirements in the Darien Zoning Regulations, and you voted to reduce them at the time from the standard of 2.5 spaces per unit down to a lower standard, but not quite down to the standard which has been dictated to you by the state of Connecticut. So in this July 13th decision by the commission, you've reduced the parking standards for multifamily dwellings, either apartments or condos, to 1 space for each studio unit, 1.5 spaces for each 1-bedroom unit, 2 spaces for each 2-bedroom unit, and 2.5 spaces for each 3+ bedroom unit. That is slightly different than the statute, which requires that the commission cannot exceed one space for each studio or one bedroom, and not more than 2 spaces for each dwelling unit with 2 or more bedrooms. So while the commission did reduce its standards, it's still slightly different for 1-bedroom units and 3+ bedroom units. And the commission's reasoning at the time, and I'll have commission members and Fred Donite chime in, the rationale was for multiple reasons. First and foremost, Darien may not be as walkable of a location as, say, downtown Stamford or other cities. So people in Darien generally rely more on cars. There are many more vehicles registered in Darien than there are people living in Darien. And I think the commission acknowledged that you can't deny those facts, that if you live in certain parts of town, you're not walking to a grocery store or a restaurant or to the train station. There are certainly many walkable places in town. We're trying to make the community more walkable and bikeable, but we have to acknowledge reality is that many people rely on automobiles. Many people have multiple cars in their family. I expect many adults, teenagers, young people drive. And at night, they need a place to put their car because the other reason the commission acknowledged, not all streets in Darien allow parking on the street, especially on-street parking overnight or during the winter time when the streets generally need to be clear for snow plowing reasons. So the commission, especially in the case of 1-bedroom apartments or condos and 3+ bedroom apartments or condos, wanted to ensure that there was sufficient guest parking, delivery parking, etc., so people don't have to park on the street or on a neighbor's property. So we wanted to make sure there was sufficient on-site parking. We did note that in the future, the commission could certainly reduce it even further if they wished. However, at this time, this appeared to be based upon the hearings in May and June and the decision in July, what the commission was comfortable with at this time. So Fred, do you have anything that I may have left out in terms of the reasoning, the procedural standards, the information that the commission is going to be basing its decision on?
But just for the record, when we changed our regulation, we knew about this or that already exists. So this is nothing new to us.
That's correct. When
we considered it
right, the commission was aware that the statute was likely to pass in some way, shape, and form. So you were aware of this when you did reduce your parking regulations.
Right. Fred, anything?
Apologies, I dropped off the meeting, but Jeremy, did you go over the different standards as what the town adopted versus the Public Act?
Yes, I think that's a good point, Fred, is we are the same for both studio and 2-bedroom units, but different for 1-bedroom and 3+ bedroom. And I think the importance of minimizing on-street parking. Many streets in Darien, I spoke to this with the RTM Rules Committee the other night. If you live on, say, Point Street or Tokenique Road or Boston Post Road, there's a lot of streets where you just can't park either in the middle day, end of the day, nights, weekends. There's just no on-street parking. So if your apartment building or condominium complex doesn't have enough parking for you on site, where are you going to put your vehicle?
We have no parking on any street during the winter.
And that's correct. There are parking restrictions in the winter on
every street.
I believe on every street. So these are factors that this is just life. And while it's great to make Darien more walkable, it's something we've been working on. New sidewalks, crosswalks, bike paths, all that stuff is great, but we can't deny the fact that you just need on-site parking for these things, and to not require it is really closing our eyes to what's going on and how people exist in our community. I can't speak for other communities.
If it hasn't already been noted, I just want to clarify that the the proposal that the parking regs that the commission adopted only differ by a half a parking space for 1-bedroom units and a half a parking space for 3+ bedroom units. Otherwise, the regs that the commission adopted match what is set forth in Public Act 2129. 1 parking space for for studio apartments and 2 parking spaces for 2-bedroom apartments.
I will note for the record that we did get a letter from a member of the public, which was put in your packets, which we will also include in the file.
Okay. You good, Fred? Let me open up to the commission. Open up to the commission, see if any commission had any questions on this. George Riley, your head's staring at me. Any questions? You're good? Kara Gately, you okay? You good? Jen Leahy's okay. And I think Jim Rand, you okay? Fantastic. And I think Jeff Ball left and will come back. So with that said, want to open up to the general public?
Sure.
I would like to open up the hearing to the general public. Does anyone in the general public want to comment on this application or this item on the agenda? Mr. Oben, your microphone's on. Please go ahead, sir.
Thank you. And I appreciate the commission holding this hearing, although I understand that you have to have this hearing to move this through. I just need a couple of things clarified. You may have covered these earlier, so I apologize for my ignorance. But my understanding is that this has been passed by the state, took effect on October 1st. So we're dealing with a clock with the state. With regards to the buildings that are affected by this, you had mentioned earlier that this would be multifamily housing units. Now, is that any multifamily housing unit, regardless of whether it's affordable or just a regular development? Okay, so we have several that are in process right now being built. Okay, Federal Realty being one that comes to mind. Would they come under the umbrella of these regulations?
That's a good point, Mr. Oben. And I think if you look at projects that are now underway, those are the 3 big projects you're thinking about: Noroton Heights Shopping Center, Federal Realty, and the Corbin project are all approved projects, which were approved under mixed-use standards, residential on upper floors, retail and restaurant, personal service uses on the first floor. So I'm glad you mentioned that. I want to talk a little bit about that situation. Number one, any project that's already been approved would have to come back to the commission to change their plans. So certainly anybody, even say Avalon or Kensett, who now would be approved under the 2.5 per unit standard, would have to come back to the commission to reduce their parking. But so let's talk about that issue. They're welcome to come back if this passes to amend their site plan and special permit approvals. Okay. Those would be Avalon, Kensett, the Heights at Darien, Royal, Garden Homes.
Right, but I don't mean to interrupt, but I'm going to interrupt. Those projects, if you walk through them today, are all underparked. So if they want to reduce their parking, they're going to build something on the thing, or else maybe just turn a parking space into grass and put a bocce court there. Relative to the other 3 projects, and I'll try to.
I'll cover that because that's a good question, Mr. Oben. The Darien Zoning Regulations relative to mixed-use projects, the regulation section 905 allow the commission to reduce down for mixed-use projects. So those 3 projects already got, instead of, the commission acknowledged that with mixed use, you're likely to get some sharing or stores being closed at night while the residents come back to their apartments. So there already was a reduction given for those mixed use projects. So whether the commission could allow them to drill down even less, I would guess the commission's going to want to wait and see before they go down too much further. I mean, clearly the projects are not complete. They're going to, and I would expect and hope that even when Mr. Ovani spoke earlier tonight about some of the new tenants going into Federal Realty, we've been very fortunate when restaurants and businesses open. There's this really big push in town for everyone to get out there and experience the new. You may recall Shake Shack was like that.
Chinos.
Pliables had a line a block long the first day they opened. So I think it's likely what would happen is the commission wouldn't want to go down too far. They'd want to kind of let these things get settled in, and there may be opportunities in the future to reduce a little more, but that reduction's already been built into those projects.
Yeah, the parking for Federal and for Palmer's and for Corbin, the three big ones, is actually a negotiated number. It's neither this nor any other one because you're blending residential, office, and retail into one. So those projects would not be affected. If Federal, for example, wanted to come back and reduce their parking again, they have to do a whole new application.
They would come back to the commission and say, we want to take away these parking spaces, move some curb lines, whatever it is.
Right.
So certainly people can't change their site plan approvals or special permit approvals without coming back to the commission.
Right, and the Palmer's application is going to come back, commission. I think it already is back. But Federal is, they're set in stone. If they need to do something for parking later, they may. But that is a good question. We did cover that once before. I think in my initial outset, I spoke of the Heights in Darien and Avalon and Garden Homes. Those are the only freestanding single plus Kensett apartment
There might be one or
complexes.
two others, but
Yeah.
So this really is going to, the
Middlesex,
focus on this will be these, I'll call it the standalone condominium complexes and apartment buildings.
Middlesex Commons is another one. Did we ask your question,
All right,
sir?
thank you. Yes, you have. May I ask one other question?
Of course.
The opt-out that the state is allowing, is that a permanent opt-out, or is there a time frame imposed by the state on the opt-out where they're saying, okay, your opt-out is only good for 2 years, and after that, it'll be re-examined or anything like that?
My belief is that it's a permanent opt-out.
Yeah.
Okay, so this is it.
Yeah.
This would be it.
They put an opt-out provision in the law for parking, and they put an opt-out provision of law for accessory dwelling unit.
Which we'll be dealing with next year.
Yeah, which we'll deal with next year.
Okay, very good. Thank you.
You're welcome, sir. Does anyone else in the general public have any questions to this application?
Yes, Amy Barsanti.
Hello, Amy. Welcome. Amy
Hello.
is the chairperson of the Planning Zoning Housing Committee of the RTM. Welcome.
Thank you. Thank you. I have two questions. One is procedural in that do we have kind of one crack at the apple for opting out? So the first attempt needs to be successful is I guess my question number one. And question number two is, has the commission deliberated on just the concept or the premise of just local control, regardless of whether or not how much your parking guidelines deviate from the state mandated guidelines, with regards to just protecting future ability to control local zoning down the line?
Well, I'll try to answer the questions, Amy, and then I'll let others chime in with their opinions. But I'll give my opinion first, I guess. Relative to the opt-out, that's an interesting question. I would presume that if either the commission or the RTM does not get the necessary 2/3 vote, that I guess the commission could try again. It would be kind of unusual in that maybe there's different members on either the Planning and Zoning Commission or the RTM. But in that case, what would happen is the state standard would apply in Darien until it's opted out of. So we would then have de facto adopted the state standard.
Because right now the state standard is in effect.
Correct, since October 1st, so
Right.
it has 4 days. Yes.
So that the state standard, and Amy, just for the record, your camera's off. It doesn't have to be on, but it's allowed to be on. But with regard to the laws in effect today in Darien for the last 4 days, but that's why we had to wait till October 1st, October 4th to put this forth. We have our existing provision, so we're supposed to, if an application came in tomorrow,
It would go with that, the state standard.
it would go with the state standard. And we had an application come in September. When did it come in? When did
The
Parkland?
Parklands application came in, Fred,
Prior to October 1st.
prior to October 1st.
Yeah. So the most recent application that we have for an apartment complex, which is going to be 3 Parklands, they came in under the old provision, not even the new provision.
And the other question's a good one, Amy. I think the commission at this time is focused solely on the parking opt-out. And certainly we acknowledge that accessory dwelling unit opt-out is something else that was put forth by this Public Act 21-29, which the commission will have to deal with. And I think for the time being, I don't think the commission is focused so much on the bigger picture, but that may change when the new legislative session starts in a few months.
Yeah, but the only I would add to that, like I said in my opening statement, Amy, when Representative Blumenthal came to our hearing, he wanted this, he liked these opt-out provisions. So it gave the town local control. I can tell you that the town of Greenwich, they do have on-street parking in some of their zones that are multifamily that are underparked, and it drives them absolutely crazy. And we don't have any on-street parking in our town. On-street parking is also a safety issue because it blocks sidewalks and it blocks people walking in through cars on streets. And then even in the winter, as you know, may or may not know, in the city of Stamford, if you park on a street that has to get plowed, you have to move your car before the storm comes and go to a municipal garage. We don't really have municipal garages in Darien, so people were parking on streets and they had to go to a municipal lot. You can't even put it at Darien High School or Middlesex School because all those lots get plowed too. There's no place you can put your car. So I think did we answer your question?
Yes, you did. Thank
Great.
you.
Does anybody else from the general public have any questions on this item on the agenda? Okay. What are we doing now? We closing the hearing? We taking a vote tonight?
No, we're not going to vote tonight.
Okay.
If the commission votes to close the hearing, we'll draft up something for the commission's review and possible action next week. Again, with the understanding that the RTM has set aside time on their October 18th agenda to vote, but they cannot have their vote if the commission does not decide it on the 12th, because then we have to publish it on the 14th or 15th,
Great.
and then they can have their vote.
Yeah, and if everyone heard what Jeremy just said, we're gonna close the hearing tonight, hopefully vote on it next week, which is gonna be, what are we, the 12th was, yeah, 12th. And then once it gets passed, which will be passed at the same exact date, then it can go to the RTM on the 18th. So we're all time. If you remember the memo Jeremy gave us at least a month ago or last month, it's a very tight time frame, the way that we orchestrated everything. Plus you also have the election cycle where people change over too.
Correct.
Okay. With that said, any other comments before we make a motion to close the hearing? Everybody's good? Okay, I would entertain a motion to close. Jim Rand makes the motion. Looking for a second. Jen Lee makes a second. All those in favor to close the hearing? Fantastic. Thank you.
5-0.
Great job, Jeremy. The next item up for bid is proposed amendments to Darien Zoning Regulations, COZR number 7-2021, put forth by the Darien Planning and Zoning Commission. Proposal to amend section 593 of the Darien Zoning Regulations to eliminate the minimum gross floor area for each dwelling unit in the Leroy-West Affordable Housing Zone, Affordable Housing Overlay Zone, parentheses LW. The full text of proposed regulations is on file and available in the town clerk's office and in the planning and zoning office for inspection online at dariencT.municipality.gov. viewpointcloud.com. That's a new one.
That's correct. We
Wow.
started a new
New
software.
address. If you all remember, we changed or we eliminated the minimum gross floor area for all apartments in town. We debated it for a couple of weeks. We had a public hearing on it. We did it in all multifamily zones except for the Leroy-West zone. The reason why the Leroy-West zone was a carve out is because our decision on the Leroy-West zoning change was being appealed by the applicant in state court. Is that what you call it?
Yep, Stanford
With care.
Superior Court.
Stanford Superior Court. That case has since been settled. The judge decided. The judge threw out the case. Is that the correct wording?
Basically, we'll talk about this in the executive session in the future, but that case was decided by the judge in the town's favor. So
So now it's the case is closed, we can reopen this.
Right, and Public Act 21-29, similar to its changes and requirements regarding parking, one of the things that Public Act did was say, very specifically, it modified section 8-2 of the statutes, saying that commissions cannot limit minimum apartment sizes, minimum condominium sizes. So based on that wording, which took effect recently with the passing of that statute, the commission has to go ahead and eliminate this wording from the Leroy-West zone. As Steve noted, you did take care of this in other zoning districts recently. In a June 22nd decision, which took effect August 1st, you eliminated reference to minimum square footage floor area of residential dwelling units in the DBR, DMR, and 3.7 AH zones. At the time, you found that that proposal, which is similar to this proposal, was consistent with the Town Plan of Conservation and Development from 2016, which says that on page 106, that the commission shall evaluate and consider eliminating size restrictions for multifamily units and rely on instead on building size and bulk standards. And on page 169, update zoning regulations to implement strategies, policies, and action steps in the POCD. So in this case, it's really right on point with the 26th Town Plan of Conservation and Development. The proposal would also be consistent with section 8-2 of the Connecticut General Statutes, as recently amended by Public Act 21-29, which limits the commission in establishing such minimum square footages. And the section we're looking at changing is section 593, and there's a chart on section 593, and it's the section that says, the standard that says minimum gross floor area of each dwelling unit, that's again minimum 1,600 square feet. So the commission would be looking to eliminate that standard in order to be consistent with the state statutes. We believe that this proposal is consistent with the 2016 Town Plan of Conservation and Development. We did refer this out to the Darien Health Department, filed it with the town clerk. We received no comments on this proposal.
Okay. Any questions, comments on this one? It's a little bit of a housekeeping item. Yes, Jim, please go ahead. Turn your microphone on, sir.
Given that the proposal focuses or is relevant only to this property, is that correct?
Yes. Yeah.
Given the history of the applications and comments and the appeals and all the rest of it, what now is practical impact on that property of this proposal?
That's a good question, Jim. I'm glad you mentioned it. The property in question is the corner of Leroy and West. On that property now is a 16-unit condominium building with 24 on-site parking spaces. All the units are 2-bedroom units, and it's restricted for elderly. So de facto,
not 65 and over, 62 and over.
Correct.
whatever.
So de facto, any change in the parking regulations, which could go through, would not affect this property because this has a lesser parking standard, 1.5 per unit. Similarly, the minimum size standard, they could not, and Jim, your question's a good one, they could not start chopping these condos in half because there wouldn't be enough on-site parking. Right now it's 16 units, 1.5 spaces per unit. They'd have to come back to the commission to chop up the units to make them smaller, and there would not be enough on-site parking for them to do so. So I think for all practical purposes, it doesn't make a difference, but it's just for us to be consistent with state statutes.
Right.
But it's a good question.
Yeah, I mean, what are you gonna do? Break up a 2,000 square foot apartment in half? Create a second bedroom and a second kitchen? It's really housekeeping.
I don't. Okay.
Yeah, it's just housekeeping. I mean, we
And
could have.
Again, this is in response to state statute changes. I think there was also a court case a few years ago which kind of alluded to this, how much the commission can limit minimum sizes. And the argument is that by allowing people to build smaller units, those smaller units will be de facto more affordable than, say, a larger unit.
Yeah.
It's really out of our hands, Jim, I guess is what I'm saying.
Okay.
All right. Thanks for answering the question.
Any other questions, comments on this one, folks? No, everyone else is good. What are we doing? Just closing this?
Yeah,
Or
if there's no other
what
from
we
the
got?
public or the commission, we can close to him.
Anyone in the general public have any questions on this item on the agenda? Seeing none, I entertain a motion to close this public hearing. Is that George Riley making the motion and Jennifer Leahy making the second? All those in favor? 5-0. Great, thank you. That one's done. Okay. This was the one letter that you're talking about, right?
That's correct. We acknowledged it one letter. In fact, that'll be part of the file.
Okay. We don't know where that person lives. Okay, next item on the agenda, special permit application number 238E as in Edward, Ethos Wellness LLC, 883 Boston Post Road. Proposal to establish a health spa including massage therapy, cryotherapy, I think it's supposed to be infrared sauna, and meditation chamber in the first floor space formerly occupied by Huntington Learning Center. The subject property is located on the northwest side of Boston Post Road, approximately 80 feet northeast of its intersection with West Avenue, and is shown on Assessor's Map number 17 as Lot 3 in the central business district. Jeremy, what do we got?
Sure. You may be familiar with the Huntington Learning site, which is on the north side of Post Road. That's about a 1,503 square foot space within an existing building. It's on the first floor. Parking is in the back. And the proposal by Amber Kemp is to establish this new business. Her narrative talks a little bit about hours of operation, staff, parking, it's kind of what they do. It's a personal service use, which requires a special permit in this zone. We did refer it out to Public Works, who had no comment. The Health Department's comments were that plans must be submitted for final review by the Health Department, and there were no local traffic authority issues. So I'm going to turn it over to Amber to explain the business, how it runs, how the whole thing will operate, parking, traffic, noise, etc. Amber, take it away.
There she is.
You got to unmute yourself, Amber.
Says hit unmute, Amber. You'll find it. There you go.
All right. Thanks, Jeremy. So I put together a brief presentation just to run through the overview of the business. So I'm just going to share my screen here. Entire screen.
Who's given access, Fred or the other person?
Okay.
There you go.
You can see her?
Yes, we can. Thank you.
Okay, perfect. So a brief overview of our business. So we're a health spa offering comprehensive health and wellness services for the whole family. So here is an entire list of our wellness services that we'll be offering. All services are delivered by licensed professionals, who we serve. So our mission is to make health and wellness available to everyone. So they're designed to serve anyone from a high school athlete to a senior citizen and everyone in between. So here's a breakdown of staff and parking as it would affect the community. At any given time, we would have a maximum of 4 employees. So 2 licensed massage therapists, 1 receptionist, 1 manager. Our plan is to have staff park in the upper Tilly lot. I know the Tilly lot at the rear of the building gets filled pretty quickly, so to a lot more room for our customers to come in, we'll park at the upper Tilly lot. Customers can park in the main Tilly lot or the 2-hour parking on the street. At full capacity, there'll be a maximum of 5 customers in the store at one time. There's 5 treatment rooms. On average, we won't be at full capacity, so we're expecting about 3 customers at a time. A majority of our services take less than 30 minutes. For cryotherapy, it's a 3-minute session, so people are in and out fairly quickly. They won't be parking for long periods of time. Here is the hours of operation, Tuesday through Friday, 9 a.m. to 7 p.m., Saturday and Sunday, 9 a.m. to 4 p.m. We'll be closed on Mondays, and customers are able to book up by appointment or walk-in. So, and that's basically, I'm going to stop sharing my screen here. Okay, great. So does anyone have any questions for me?
Yeah, Amy, do you have on your screen the, Amber, I'm sorry, do you have this?
The floor plan.
The floor plan?
The floor plan. I don't, I'm not, let me,
Well, that's okay. You can help me out then. I'm just, I'm taking the back of the building.
Will there be a door that you're going to use both in the front and the back, or just the back?
Yeah, retail and storage in the back. You said 5 rooms. I'm just trying to make sure I know where the 5 rooms are. That's all.
yeah. I'm looking at the floor plan, that you're looking at. So the 4 treatment rooms are to the left if you're coming in from the front.
Let's start with the front door, the back door. Which one is the front door?
The front door, it walks immediately into the reception area.
So the front door is on the right of this thing.
To the left. So you see there's a reception, the retail, and the storage.
Okay.
That's the front door.
That's the post road. Okay. Yeah. Got it. All right. Then you have retail up front, storage, reception. What's the next word? Is that say employees?
Yeah, just an employee area.
Okay. Employee. Then you have 1 treatment room, 2 treatment rooms, 3 treatment rooms. The first one says PBM. The next one says teach you or tech you. The next one says massage.
Yep.
Okay. Then the last one up top is cryo.
Yes.
Right. So that's 4. Then the bottom you have 5 is where it says massage.
Correct. Yep.
Yep. In the middle, I think that says Zen. Is that the Zen room?
That's the feel of the room. It's a waiting area. Also, stretching would happen there. Assisted stretching.
Got it. Okay, so that's your 5 treatment rooms. we wish you success to have all 5 rooms occupied at one time. That's the goal.
That's the goal. Yes.
Right, so that would be, you said 2 employees, a manager and a receptionist, right?
Yes.
So I can go into the cryo room and no one, I just sit there by myself, right? No one stares at me, do they?
They do have to guide you in. So it's an observed treatment.
But
Just
you
for
don't
safety reasons, someone's walking you in, you have some clothing on, and you're going in for a maximum of 3 minutes, and then you're coming out.
Yeah, it's only 3 minutes, okay. Because my back is killing me. All right.
Cryo is your fix.
There you go. Okay, and the parking's up top. There's plenty of parking spaces up there. It's a public lot.
That was my question, Amber. Is going to be parking? Will customers be able to come in both the back door and the front door?
Yes, they will.
This is a real.
Steve,
Mostly,
I've got a question for Jeremy, if I may.
Go ahead.
This is nothing having to do with this application. It's more general. Is anybody keeping a track on how many people we've allowed to park, employees, clients in any of these lots? I mean,
actually, to answer your question, I just got the parking study from Kate Bush a week ago on how many permits are there and how many lots are, how many for each lot. I don't remember exactly what it says for Upper Tilly.
Yeah, that's a good question, Jim. I have been back to that Upper Tilly lot, which is kind of up one level. It does get pretty full. If you're an employee who just say works afternoons, you may find difficulty in getting a spot in that lot. You may be ending up parking across the street, I'll call it behind Heights Pizza or behind the fire department in the Mechanic Street lot. That is more likely where Amber's employees will be able to get parking passes for, but it's just right across the street. If they can't get into Upper Tilly, certainly I will acknowledge for the record that Captain Treaders and I, the police department, did go out last week, earlier this week, and there were some concerns, especially as we get down by Comm and Little Thai Kitchen, that if the parking lot on that lower level is full, there's really nowhere to turn around. So it is likely that the town over the next couple weeks will take one of the parking spots near the end and turn it into a turnaround space. So if you get into that parking area that's all full, at least you have somewhere where you can back in and turn around and find somewhere else to park. Because there's, from what I understand, there's certain times during the day that it gets crowded. Certainly, Amber's business seems to be more spread out, more weekend activity, if you will, some in the evenings. So it might be a nice complementary use, maybe even more so than Huntington Learning, that was really hitting the same prime time as Comm.
Right.
So I will note that for the record, that there's likely to be a small change, and employees may need to park across the street.
But again, this is a 1-for-1 where Huntington Learning's going out and this new wellness center is going to go in. I think if my memory is correct, there's more teachers at Huntington Learning Center than there is massage therapists at Wellness, at Ethos. Okay.
Thanks.
Any other questions? Jen, you good? Got a smile on her face. George, you okay? Yep. I think Kara dropped off and Jeff dropped off. All right, that's it. Would anybody in the general public like to speak to this application? We don't have anybody else in the general public here. Amber, it looks like you're good. Any questions, any closing items? You got a smile on your face? You can tell your friends that you're okay. With that, entertain a motion to close the hearing. Made by Jen, seconded by George. All those in favor, say aye. What's going to happen, Amber, is we're going to make a debate this next week. We debate it next week, you think?
Next week, we'll try to get a vote next week.
You're going to draft for it next week?
We're going to try to rush it through. If not, it'll be the week after.
All right, Amber, you're gonna have your final answer in the next week or two. You'll have your final answer next week, and then you'll have the documentations either next week or the week after. Okay?
Great. Thank you very much.
You're welcome. Thank you for coming to town. All right, next. We're still in the general meeting, deliberation and possible decisions on the following hearings that were closed on September 14, 2021. We have two draft resolutions. I'll read the first one into the record. Coastal Site Plan Review Number 359, Flood Damage Prevention Application Number 413, and Filling and Regrading Application Number 511, William and Elizabeth Jones at 2 Contentment Island. The Yankees are playing tonight, and I'll try to get home to the game. So let's see if we can go through these two resolutions.
You want me to run through them?
You want to run through them? Yeah, these were ones that I reviewed after the fact. But any questions, comments, Scribner's errors, typos, and any resolution anybody read so far? No? Okay, Jeremy, go ahead. What do we got?
Yeah, you may recall that the main issue on this was the comment from Holt Smith of the Tokenique Association about the potential for a new wall up against the right-of-way to block water, which traditionally has flowed onto Mr. Jones' property. The attorney for Mr. Jones said, well, it's all nice and good. You've been draining water onto my property for 40 years. However, I would prefer you don't do that. And Mr. Tibbetts specifically said, we'd be glad to work with you on trying to find a solution, but clearly just because you've been draining onto my property, you don't have an easement, and we would prefer it not happen. So we talked about that in finding number 20 on page 4. The rest of the resolution is straightforward. Because it's work in the flood zone and it's a lifting of a house, that we are requiring a elevation certificate in terms of condition I, and that all mechanical units be located at least 1 foot above the base flood elevation. So there'll be one separate permits for both the house additions and alterations, a separate one for the pool, which will have to be specifically designed because the in-ground pool will be in the flood zone. But this is a great thing because as part of this application, the non-conforming tennis court will be removed, and the house will now be conforming relative to the flood requirements. You may recall that the application received a variance from the Zoning Board of Appeals. So that's the draft resolution in a nutshell.
Okay. Any typos? George, you find any typos? Jen? Nothing? We're good? Jeff? Everyone's good? Okay. Thank you, Jeremy. Fred and Jeremy, once again, did a fantastic job. You can't find anything wrong with it. With that said, I would entertain a motion to approve as submitted. All three at one time. Whose turn is it? I think George Riley's turn makes the motion. We're going to make Jen the seconder. All those in favor? There you go.
4-0.
4-0. Fantastic. The Yankees are actually down by 2. Next item up for bid. Coastal Site Plan Review Number 361, Flood Damage Prevention Application Number 414, Land Filling and Regrading Application Number 514, JMM Investments Fairfield LLC, 14 5 Mile River Road.
You may recall at the hearing, this was also fairly uneventful. This is the construction of a replacement house at 14 5 Mile River Road. The subject property is on the west side of 5 Mile River. It does not have any water frontage. Only the most front part of the property is in the flood zone, which is basically the driveway. And the only work they're doing in the flood zone is connecting to utilities and repaving the driveway. So from that standpoint, there was a little regrading associated with the side-facing garage. The new house basically meets all the setbacks, building coverage. The pool will require a separate zoning and building permit. So this was pretty straightforward. There were no comments from the public at the hearing. We heard from Land Tech, who designed the project. Stormwater management was included. So from this standpoint, we drafted a resolution to grant the project with stipulations.
Questions, comments, Scribner's errors, typos. I like saying the word Scribner's errors. It's a fancy word for typos. Right? I didn't see anything in this one when I reviewed it also. Once again, these guys do a good job. again, they have to file a maintenance plan, a water maintenance plan with this thing, right?
Correct.
Yeah, the thing that we just have to seriously watch on these applications, some of these people are building houses in flood zones. We had that long hearing, or the Board of Selectmen had that long hearing a while ago that talks about it. Some people are buying houses in flood zones and don't know it. But if they're lawyers, and we have a couple lawyers on our commission and a realtor, make sure that their buyers beware that they are buying houses in a flood zone. That's why there's provisions in there. Anyway, little side comment, sorry. With that said, no questions or comments on this thing? I would enter a motion to approve as submitted. I think it's Jennifer's turn, and Jim Riley, you get this. Jim Rand, you get the second. Jim Riley, that's a nice one. All those in favor? 4-0.
Thank you.
There we go. That one's done.
Yep.
Okay. Next item. We're cruising. 9 o'clock. Deliberations only on the following item for a hearing that was closed on the 14th. Coastal site plan review number 256B as in boy, flood dam prevention application number 287B, land filling regrading application number 513, Noah and Kristen Charney at 9 Butler Island Road. Proposal to construct, in addition to the residence, and construct patios and a pool over an existing patio, install stormwater management systems, perform related site development regarding regrading of the property, and perform related site development activities within regulated areas.
Right. The hearing on this case was fairly uneventful as well. You may recall the subject property has a lot of ledge and rock outcrops in it. We talked about the pool, which is on the west side of the house, which will be up on a platform. One of the concerns was the amount of ledge. How is it going to be removed? How many days will it take for that ledge to be either hoe rammed or blasted, chipped away? The applicant also got a variance from the Zoning Board of Appeals to head on over the garage, which is on the eastern part of the site. If I recall, there were no members of the public that had any significant comments. The hearing was fairly uneventful, but there is some regrading to create this platform for the new pool.
Do we limit them on days of blasting or
I
days
think that
of
was one
programming?
question that Doug DeVestis spoke about during the hearing. We'll have to check my notes on that to make sure that they don't start chipping away or blasting the whole site, but really limit it to the areas they need. In fact, I think they did talk about one area that's shown on the plan. They're not going to chip or blast in that area as well.
Well, quick question. I know for blasting, you have to notice the neighbors. We have to do that for chipping.
For the fire marshal, you need a blasting permit from the fire marshal. Whole ramming, you do not.
Okay. Okay.
So if the commission has any other questions on this, if not, we'll draft something for next week's meeting. So if you have anything, send us an email. If not, we'll get started.
Anything specific that anybody wanted inside this resolution at all? No? Okay, good. So we'll instruct staff to draft a favorable resolution on that one. The next item on the agenda is other business that requires 2/3 vote of the commission. We have no other business except for the Yankees are down by 2. We do have business.
It's going to take 30 seconds, but if I could ask the commission to go into other business to briefly discuss the very simple items we talked about tonight, so Fred and I can get started on drafting. Those would be ethos, the opt-out on multifamily parking, and the Leroy-West zoning change.
Okay.
2 minutes on each.
So let's go other business. I need, we have to
Motion.
both to approve, go into other business, please. Jim made the motion. Jen made the second. All in favor? Okay, other business. Let's go ethos first. Okay?
Yep.
Any questions on ethos? The wellness center? It's if you look at the floor plans and you look at the Huntington Learning Center floor plan, they're doing like zero construction. I think they're taking out desks and putting in open space. So it's just a 1-for-1 replacement business, probably less intense than the other one. Everyone okay with that one? Yep. Okay. That one you're good to go.
Okay, thank you.
The next item I'm going to talk about was
Leroy-West.
Leroy-West. That's just a house cleaning item. You know, we didn't put it in last time because it was in litigation, if that's the correct wording. I got you, Jim. Now we have to do it now to be in terms of their process. Yes, Jim?
If it's just housekeeping, why are we doing it?
It's state law. You have to do it. You were supposed to switch
Thank you.
over. Say again?
Is somebody gonna come down from Hartford and spank us if we don't do it?
You're supposed to take out all the.
This thing has been so litigated and appealed and now thrown out of court.
Yeah. Well, what we did.
Bad taste in my mouth about this whole goddamn thing.
No, you're right. But what we did is we eliminated the minimum apartment size in all multifamily zones 6 months ago. We took it out of everybody. We did not take it out of this one because the thing was under appeal at the time. Now the appeal settled, so now we have to take it out anyway. But there's never going to be another building ever built inside the LW zone. There's never going to be another building in an LW zone. It's spot zone. They can't do anything with it. It's 100% house cleaning. That's all. George,
We're not doing any favor.
what's that?
As long as we're not doing them any favor.
Well, clearly, this is not a favor for them.
Yeah, no.
In fact, I want to note that as part of the application, we did do the courtesy of notifying everybody who lives in the building, as well as their attorney. So you can't say we're trying to pull a fast one. They were all notified by certified mail. So that was we thought it was a nice thing to do, to at least alert them, and you could see that no one really commented. So that's good.
All right. So if they had, right now there's 16 apartments in there. 5 of them were sold, and the other 11 are not. So if they, for argument's sake, say they split 2 of those apartments in half and created, they'd have to add new parking spaces, and they don't have any. So it's if they had a kitchen, and I think that building also gets the highest rents in multifamily apartments in the town of Darien. Okay, everyone good with that one? Okay, do that one.
Thank you.
What was the third thing?
Opt out for multifamily parking. We want to try to see if we can move that along so the RTM can vote on the 18th.
Anybody have any
any thoughts on
questions on that? We've gone over this hundreds of times. We're all on the same page, right? I mean,
Okay, great.
we
Good,
just,
I'll get started.
the only thing we have to do as a commission, we have to make sure we get the RTM on board, and that there's no questions there. So if any RTM member asks you any questions on it, please, ask, answer them as best you can. I can tell you that Jeremy has already had a meeting with, I think I was invited and I spaced, I missed it, with the planning housing.
We met with planning, zoning and housing. I met with them once.
Yeah.
I'll meet with them again next Wednesday. Met with rules last night. So certainly we're trying to lay the groundwork and get everyone informed. The good news is the rules committee did seem to be favorable. So that's good news.
And then weren't we also going to go to Board of Selectmen and get them to
We
chime
did
in?
go to the Board of Selectmen
Did they take a vote?
in September. They did not vote, but they also were quite favorable.
Okay.
So that's good news.
I'd like to have the Board of Selectmen take a vote to back us up with the opt-out provision too. I mean, our parking's fantastic. Anybody else?
Nothing else.
Okay, that's end of other business. Next upcoming meetings, October 12th, we're gonna see the 26 East Lane special needs building that was basically completed and waiting to get a C of O. That's one of the affordable housing components for the Corbin project. There was some state regulations that they need to tweak to be compliant. The state asked them something, there's some wording there. And then on October 19th, that's going to be a dedicated special permit night, special meeting night for the Parklands. 3 Parklands, at 3 or 1?
Parklands. So it'll be a full night. Basically, the presentation on October 19th will take most of the night to talk about the proposed apartment building at 3 Parklands, which is right behind the assisted living facility. So we'll hear from the architect, the engineer, about drainage, grading, a little bit about the look of the building, traffic, parking, noise, lights. It's going to be a lengthy presentation, so we've set aside pretty much the whole night for that application.
That's nice. And if you guys can brush up and find the book that they put together when they made the zoning change, that's in there. It was a white binder from Redness and Mead. And just as a future note, on October 26th, which is the day after my son's birthday, that Noroton Heights Shopping Center, which is the Palmer's Shopping Center, resubmitted their application to staff last week.
Yep, they'll be coming back for some changes to their originally approved project. So that too will be a full night presentation to talk about traffic, parking, looks of the buildings, every lighting, everything. So they're coming back. The changes are not too significant. I think I've seen the preview, but it is going to take a while to get all the information on the record. So it's 3 full nights coming up for the commission. And then November 2nd, which is election day, we're going to cancel the meeting that was scheduled for November 2nd.
Cool. The farmer's application, we're really trying to get that thing going again. Obviously it's been stalled. There's some capital partner that stepped in to help with that project. And they're making substantial changes, but they're really tweaks and a couple items. There's a couple of things that pop off the page. If you want to see a prelim of the application, you're more than welcome to come into the office and take a look at it. All right, with that said, I would entertain your motion to close the meeting. Jim Rand makes the first, looking for a second. Jen makes the second. All those in favor? The meeting is closed. Thank you, everybody, for participating. Appreciate it. Have a great night. Yankees are still losing. Yankees down by 3. Bye-bye.
Well, smooth as could be.